Hello, everyone. I'm Brittany Falkowski. I'm a partner in Husch Blackwell's Labor and Employment Group, and I am joined today by my colleague, AJ Weisler.
We are back this fall with our virtual seminar series, and we are glad to have attendees with us today from all over the United States.
And although we do really miss our in-person seminars, we have grown to love these virtual opportunities so that we can reach a really wide audience of our clients and contacts all across the country. It also gives us an opportunity to work with our colleagues across Husch Blackwell offices. Before we begin, we would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today.
If you have any questions during the webcast, please submit those using the question box, and we will respond to questions during the webcast today as time allows. And a PDF of the presentation and other resources are available in the resources folder.
This program has been approved for HR and legal education credit. To report your hours, you just click on the CEU icon at the bottom of your screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, and that's along with a recording of our webcast for watching and for sharing.
You're going to want to share it. So toward the end of the program, be sure to complete our short survey. We often try to use your feedback to plan our future programs, and we want to make sure that they are applicable to your business needs. Now, that's all for our housekeeping items, so let's get started with our program.
Sounds good. All right, we have 3 sections of content for you today. All 3 are going to be about 30 minutes in length. We're going to have short breaks in between each of those sections, so if you need to step away for a few minutes, that's a good time to do that. But for everybody who wants to stick around, we do have some things planned, so don't worry, you won't be just stuck listening to elevator music.
Ashley Jordan, Amberly Morgan, Rufino Gaitan, and Kelly Mylink will kick off our program with a national legal update, including an overview of changes that employers can expect to see under the Biden administration.
And then after that, we're going to have Eric Eisenman, Sunny Nolan, and Eric DeLay, who will be discussing COVID-related considerations, including President Biden's recent executive orders on vaccine mandates, OSHA's emergency temporary standard, and some lessons that we've learned over the last 18 months.
And last up today, we have Julianne Story, Barb Grandjean, and Ann Mayette, and they'll explore the increasingly complex role that gender is playing in the workplace, including discussions about pay equity, pregnancy discrimination, and gender identity. Ashley and Amberly, over to you in the studio to start things off.
Good morning or good afternoon, depending on your time zone. My name is Ashley Jordan. I'm a partner in the Denver office, and I'm so pleased to be here today. And as my co-presenter, I'm here with Amberly Morgan, who is full of California employment expertise. And the two of us today are going to give you a brief legal update on national developments in employment law, as well as some California developments that we believe would be of interest to you if you have any California operations or thinking about having California operations or employees in that state. So we'll go ahead and get things started. We have a lot to cover in a short amount of time. What we're going to focus on today really is Department of Labor developments at both the federal and state level, as well as case law, including at the U.S. Supreme Court level. We are not going to be able to touch on a lot of the COVID pandemic legislation that has taken effect over the last 12 to 18 months, but don't worry, we have presenters who are going to cover that a little bit later. So the first thing that I want to bring to your attention is the DOL clarification of independent contractor status. This is always a gray area for employers, and they come to us with a lot of different questions. There's just not a one-size-fits-all for this test, and the DOL has given a little bit more guidance that helps us. They're really focusing now on the economic realities of the working relationship, and the question to ask is whether or not the worker is economically dependent on another business. So there are a number of factors that the DOL says that we should be looking at. I'm just going to point out the 2 primary ones have to do with, 1, whether or not the employer has a large degree of control or supervision over the work. If so, that's probably going to lean more towards an employer-employee relationship rather than an independent contractor classification. And the second core factor is whether or not the worker really does have an opportunity for profit or loss based on initiative and or investment. If the worker has that opportunity, then the scale may be tipped towards an independent contractor classification rather than an employee. So those, along with the other 3 bullet points, those are things that you should really consider when you're deciding whether or not to be aggressive with that classification. I'm going to go ahead now and let Amberly talk about some wage and hour issues in California.
Thanks, Ashley. And you may already be aware that over the last several years, California has codified a much more stringent test to determine whether a worker is, in fact, an employee or an independent contractor. The test in question is referred to commonly as the ABC test. And you'll notice one of the primary factors there is whether the worker is performing work that is outside the usual course of the hiring entity's business. And so as an example, if you are a retailer and you hire a plumber to come in and work on plumbing within the store, that would be an independent contractor relationship under that test. But if you have, for example, somebody coming in to do your window displays, that's a much closer call and most likely would be an employee relationship. The applicability of this test has been somewhat in flux. The voters passed what we call Proposition 22, which carved out an exemption for app-based transportation workers. Just recently, a California Superior Court stayed that the applicability of that proposition, saying that it was unconstitutional. So I think we're continuing to see some changes as far as the scope of the ABC test. In addition, the statute itself has a number of exemptions and exceptions whereby you would then apply the economic realities test that Ashley discussed. Turning it back to Ashley, we'll talk about the employee exemptions.
That's right. So effective January 1st, 2020, the DOL did enact it enacted it before, but it became effective January 1st, 2020, a new salary threshold for white collar exemptions. And this has to do with overtime pay. And so that threshold was increased from $455 a week to $684 a week, or a little over $35,000 annually. So this was quite a jump.
And Ashley, that $35,000 threshold, that applies whether or not the employee is working part-time or full-time, correct?
True. The DOL provided very specific guidance saying that this threshold applied whether the worker is part-time or full-time.
Thanks for clarifying. In California, of course, the exemption amount is quite a bit higher. And I just want to draw your attention to the fact that as our state minimum wage increases every January 1st, so does that exempt threshold. And similarly, it also applies regardless of whether the worker is part-time or full-time. A couple other wage and hour developments that we want to focus your attention on for California are with respect to the practice of rounding and time punches. In February of this year, the California Supreme Court determined that the practice is not permissible with respect to the mandatory meal periods to which non-exempt employees are entitled. Essentially finding that if even 1 minute was not provided of the mandatory 30 minutes, that it would be a non-compliant meal period. So you'll want to examine whether you are using time rounding in California. Relatedly, the California Supreme Court in July determined that the rate of pay that an employee should receive with respect to meal period penalties for non-compliant meal periods and also non-compliant rest periods is the employee's regular rate of pay. That's the same rate that's used to determine overtime compensation. This is a departure from a prior California appellate decision that had endorsed the use of the employee's base rate of pay. Unfortunately, this is also a retroactive decision, so you'll want to be looking back at how you've been paying your meal period penalties over the last year. In addition, we have had some significant expansion with respect to family leave in California. The California Family Rights Act is the state adjunct to the federal FMLA. And covered employers are now employers with 5 or more employees anywhere within or outside of California. And so that is a significant expansion. In addition, the 50 employee within 75-mile limitation has been eliminated. So you'll want to be aware, if you have an individual working from home remotely in California, they may be entitled to family leave. The circumstances for which family leave is available have also been expanded as far as military leaves. I'm not going to go into those in detail. And of course, the key employee exemption has also been eliminated. That is still available under the FMLA. This year, beginning in January of 2022, there are additional categories of individuals for whom a covered employee can take leave to care for. That includes a parent-in-law and a designated person. Turning it back to Ashley, we're going to talk about some Supreme Court case law over the last 2 years.
That's right. Thank you, Amberly. So the U.S. Supreme Court has issued a few decisions that we wanted to bring to your attention. The first is from last summer in June of 2020, where the High Court stated that an employer who fires an employee for being gay or transgender violates Title VII. So in that case, obviously, the U.S. Supreme Court is expanding the definition of who is a member of a protected class and what groups of people are protected pursuant to Title VII.
Thanks. And with respect to arbitration, the Supreme Court has reaffirmed that it is the arbitrator's decision to determine whether an arbitration agreement is enforceable in a particular context. There is no wholly meritless exception. In California, we're calling it a bit of a whipsaw. Effective January 1st, 2020, the legislature prohibited the use of mandatory arbitration agreements as a condition of employment. That was immediately stayed before it could become effective. However, this September, just a couple of weeks ago, the Ninth Circuit lifted that stay. The current status of the law then is that the use of mandatory or even opt-out provisions are not permissible. Existing and otherwise enforceable arbitration agreements continue to be enforceable, but any practices in terms of onboarding or trying to implement arbitration agreements with respect to existing employees need to change a little bit. Turning it back to Ashley, we have some EEO1 data requirements to talk about.
That's right. I want to make sure that no one's going to miss the deadline. It's 2 weeks from today to get your EEO1 data reporting in. There has been a reprieve up to now for 2019 and 2020 due to the pandemic. The DOL has stated there will be no further extensions. So if you are one of the employers who's required to submit that data, you have 2 weeks to do so.
And similarly, California employers with 100 or more employees in or outside of the state have a separate EEO1 data reporting requirement to the state of California. It's only mandatory with respect to the data for employees within the state. You can report it for everybody, but it's that has been in effect now since March of 2021, I believe. As of now, California is the only state that currently requires a separate reporting to the state. However, Illinois recently passed a new law in March that is going to require Illinois employers to report similar data to the state beginning in 2023.
So we've now spent some time looking back the last 12 to 18 months on what has been going on in employment law that we wanted to make sure that you are aware of. And really now we wanted to spend some time looking forward and some things that we're really keeping track of and that we're anticipating in the next few years under the Biden administration. What we've listed here are a few of the top topics federally that we're looking at. We do anticipate that there will be more stringent requirements with respect to non-compete provisions in agreements. We're also anticipating activity in the paid leave law area. So similar to the FMLA, but with a paid component instead of just unpaid leave. We're looking at the Equality Act, and we're also monitoring the Raise the Wage Act. The federal minimum wage is still at $7.25 and hasn't been increased since 2009. So we're seeing some activity in that area and are looking to see if something will actually be enacted there. And finally, at a federal level, we are also anticipating some increased endeavors to eliminate pre-dispute arbitration and class action waivers. That continues to be a pretty heavy area of activity, and we don't think that that's going to change in the next couple of years. Amberly, are these the types of things that you're thinking California is going to see, or are there something different that you want to tell our audience about?
Sure. Thanks, Ashley. Of course, California already prohibits the use of post-employment non-competition agreements. We have numerous state and local paid leave laws. We have a state Pay Equality Act. And as we just discussed, pre-dispute arbitration waivers are in, arbitration agreements are in question. Looking forward, I see a continued and expanded focus on joint employment issues in California. As a cautionary tale, you may be aware of the eye-popping $137 million verdict against Tesla last week. And this was for a contractor. It wasn't even Tesla's employee. So looking forward, we're going to see higher settlement value for race discrimination cases. Certainly plaintiffs' counsels are going to be emboldened by this decision. Regardless, I'm certain it will be reduced on appeal or settled in that process. But nonetheless, that is definitely an area to watch for if you use staffing agencies or if you are a staffing agency. I also would foresee increased and continued enforcement efforts by Cal OSHA with respect in particular to COVID-19 safety measures. Those will be in response to employee complaints and otherwise. And of course, we do have our own separate emergency temporary standard in the state, which differs a little bit from the federal OSHA standard. And with that, I am going to turn it over to Kelly to talk about some recent developments in the immigration space.
Thank you, Amberly. Thank you, Ashley. Ashley was talking a little bit about what to expect under the Biden administration in terms of employment law. Now we're going to look to what to expect under the Biden administration in immigration. And then Rafina will close us out here talking about what to expect in labor law and at the NLRB. But first, immigration. And I will attempt to answer the first question that I get from everyone, which is, do I need to cancel my holiday travel plans outside of the country? And the answer is, I don't know. Many countries still have travel restrictions, COVID-related travel restrictions for US citizens in place, and are slowly opening up to vaccinated travelers. Here in the United States, we do still have a travel ban in place for 33 countries that is affecting anyone who is not a US citizen, not a permanent resident, or aren't subject to a list of exemptions. We have been talking about, or the Biden administration's been talking about, having an exemption for fully vaccinated travelers starting in November, but we just don't have enough detail or a policy or any sort of order yet to know what that will look like, what vaccines qualify or will qualify. Although there's been some talk and we're just sort of waiting on that from the CDC. This is, of course, causing a lot of issues between global companies who are trying to get maybe German technicians here to work on their machines at their facilities, CEOs who need to attend board meetings. And so we'll see what happens here in November. Consular delays are also a problem. So individuals who need to get a visa from a consulate abroad to get to the United States, where it used to be they could get an appointment in 2 weeks. COVID back in March sort of closed all of the consulates, and we're just now seeing those consulates sort of open their doors just a little bit to be able to have people come in, apply for their visas, and then travel to the United States. It's not uncommon for those travelers to see an appointment calendar at a consulate that says you don't have an appointment until March of 2022, which is a long time to wait if you're looking to get to the United States sooner rather than later. In the visa sponsorship space, U.S. Citizenship and Immigration Services adjudicates those employer-sponsored visa petitions. And under the Trump administration, we were still seeing these very long processing delays. And that certainly has continued under the Biden administration. So all of these visa petitions are taking a long time. Applications are taking a long time. We do have a new USCIS director in place for the past couple of months. So we'll see if we'll see some efficiencies there. But I'm not sure just yet until I actually see it. Even if you are an employer that doesn't sponsor, employees for work authorization. You might have employees who have work authorization through some other program. DACA would be one example. These delays are causing issues for those individuals. For example, if you are a DACA grantee and you have a work card through that program, the earliest you can apply to extend your work card is 6 months in advance. Well, the processing of those work cards are now at 9 to 12 months. So if the employee has done exactly as they should, applied on the earliest possible date, there's still maybe a period of between 3 and 6 months where they cannot work, and you as the employer cannot employ them. So employers really need to be paying attention to their I-9 processes, maybe paying attention to the employees who have expiring work authorization, because where usually they'll just present a new card. At no fault of their own, they might be in a situation where they're just losing that work authorization for a period of time. In terms of Form I-9 in E-Verify, which is something that sort of affects everyone, all organizations are required to complete Form I-9s for their employees. It's important to think about sort of what the Biden administration is going to do in terms of enforcement in this space. So Form I-9 is that form you fill out to check the identity and work authorization of every new employee that you hire. We have always seen really tough enforcement, kind of starting with the Obama administration. The Obama administration attempted to sort of enforce the I-9 rules through I-9 audits. So having an auditor show up at your door saying, we'd like to see those I-9 audits, and then issuing fines for any of the I-9s that were not in compliance with the rules. Under the Trump administration, we still saw that tough enforcement, but we were really seeing more larger scale raids, going after employers for having a pattern or practice of hiring undocumented workers, and particularly contracting with organizations or companies that had unauthorized workers. The Biden administration sort of shifted back to the Obama administration, sort of using those I-9 audits to enforce the I-9 rules. And so we're seeing sort of more I-9 audits. And then we're also seeing these E-Verify desk audits. The desk audits usually come in the form of a friendly email from an E-Verify desk auditor. And what they do is they say, hey, it looks like your E-Verify practices just aren't really in compliance with the E-Verify program. And it's time to think about, going back through, looking at your practices and getting everything back in compliance. Oh, also, you have 30 days to do so, or we're pulling your participation from the program. This might seem like, well, at least it's not fines. Fine, E-Verify is a voluntary program anyway, go ahead. Except that if you're an employer that's a federal contractor, or you are required by the state to use E-Verify, and you do not respond to these emails, pulling your E-Verify participation could have serious consequences. So paying attention to those emails that come in, making sure that your contact in E-Verify is up to date, so those emails are actually going to somebody who's going to respond, is really important. Finally, we did see some COVID-related Form I-9 flexibilities that came into place back in March of 2020, and they are still in existence at least until December 31st of 2021. And what this means is it allowed employers who had remote workers or they had shut down their offices to complete the I-9 process remotely. It was a great benefit, particularly when offices were shutting down. The problem with this is that even though the flexibility policy is still in place until December, if you are an employer that has now opened your doors, you have employees on site, you may not be able to take advantage of this remote verification flexibility that's in place. So it's important to understand that you need to be taking a look at the flexibilities, making sure that your organization either qualifies or doesn't to be able to take advantage of that. And start thinking about what you are going to do if you are using that flexibility after December 31st if it's not extended. So in a nutshell, that was a quick overview of what's going on in immigration. And I'll turn this over to Rufino to talk a little bit about what's going on with the NLRB.
Thank you, Kelly. So keeping with Kelly's theme about changes in administration, the NLRB is really no different. And what we're starting to see now is definitely a sea change in terms of the NLRB's priorities. And first issue that I'd like to highlight for you is that the NLRB now has a new general counsel, and her name is Jennifer Abruzzo. She was sworn in July of this year. She has a past union experience, actually worked for the Communications Workers of America as one of their in-house counsel, and previously also served as a deputy general counsel at the NLRB during the Obama administration. And Ms. Abruzzo's general philosophy to enforcing the National Labor Relations Act is that she essentially believes that there is not an equal playing field for employers and employees and the unions that represent those employees. So her philosophy has essentially become that she's going to vigorously enforce the NLRA as it relates to employee rights. So with the change in the presidential administration, the NLRB and through the Office of the General Counsel has announced some of its new priorities. The list that you see on the screen now is not a complete list, but it does highlight some of the key issues where we're going to see some really sort of 180-degree turns from what we saw under the Trump administration and what we can expect under the Biden administration. There's a couple on this list that I'd like to highlight, the first one being the confidentiality provisions. And in this regard, Ms. Abruzzo is prioritizing going after confidentiality provisions in employee handbooks, as well as in separation agreements, and even as far as arbitration agreements. So as most employers know, one of the benefits of settling a discrimination claim or any other type of employment claim is that you get a confidentiality restriction on that individual or that employee, and they're not allowed to talk about those circumstances, especially in the arbitration context. According to Ms. Abruzzo, the philosophy she's taking in the interpretation of the act is that some of those confidentiality restrictions, even in the post-employment context, may violate Section 7 of the NLRA. And then the other priority that I'd like to highlight is what I'm referring to as available remedies, but in particular, Ms. Abruzzo is creating this category of what she refers to as make-whole remedies. And in general, the NLRB does have some wide latitude in fashioning remedies that it seeks against employers for violations of the Act. However, Ms. Abruzzo's philosophy on this issue has been that the typical remedies that the board has gone after, which include things like back pay, lost benefits, so if an employee is terminated unlawfully, generally some of the benefits that employee receives as part of the adjudication of a claim is things like lost vacation pay for the unlawful termination period, potentially reimbursement of COBRA expenses that that individual incurred. However, under General Counsel Abruzzo, what she has now instructed all of the regional directors to do is to seek, at least in respect to unlawful terminations, she wants to seek consequential damages. So what does this include? It includes things like not just lost pay, but also any financial loss that the employee has experienced tied to the termination of his or her employment. So for example, if an employee is unable to pay a credit card bill and incurs late fees and finance charges because he or she is no longer employed, Ms. Abruzzo is saying that is a consequential damage that is tied to the unfair labor practice, and therefore the regional directors should pursue those types of remedies when litigating these cases. Another example would be if the employee happens to lose a home or a car because of the termination, she wants those regional directors to seek those types of consequential damages. In the context of violations that occurred during a union organizing drive, Ms. Abruzzo has again directed the regional directors to pursue remedies like pushing for access to by the union to that workforce. So some of the access that she would like to see would be things like not just providing employees contact information, but equal time to employees so that a union can also essentially have its own captive audience meetings with that workforce to talk about the benefits of unionization. reimbursement of unions' organizational costs. So in this context, what she's looking for here is if an employer has committed an unfair labor practice in the context of a union organizing drive, she wants employers to then pay for that union's expenses for a redo election. For those of you who have kept up with the Amazon election in Bessemer, Alabama, you know that the NLRB has essentially ordered a redo of that election. According to Ms. Abruzzo, then Amazon should be held responsible for the costs incurred by the union in having to redo that election because of the alleged unfair labor practices. And then with respect to refusals to bargain, so for those of you who have unionized workforces already, she's seeking not just financial damages, but also is looking for bargaining orders that set a specific schedule for when the employer must meet with the union to discuss bargaining proposals, the submission of progress reports on a regular basis to the region so that the regional directors have the ability to determine whether the employer is complying with its obligations to bargain. So in short, really the takeaway from Ms. Abruzzo's requirements for these regional directors in terms of consequential damages and these new remedies is that she is really making it much more expensive for the employer who is facing an unfair labor practice charge to even consider settling. The other issue that she has highlighted has been that she wants the regional directors to seek these types of remedies in the context of settlements. So when you're talking about settling for the full value of a claim, a lot of employers might think, well, why would I settle for full value if I can litigate and take my chances with litigation? So really, at the end of the day, if an employer finds itself in this sort of situation, it's really going to have to consider the pros and cons of settling versus litigating the case on the merits and hoping for a better outcome than through the voluntary settlement process. And with that, that concludes this portion of the presentation, and I'll hope that you continue to join us for the rest of the program today.
Thanks so much, Rufino. In order to qualify for our continuing education in some states, we are required to have 3 poll questions during our seminar today. So we're just going to go ahead with our first poll question now.
So as you should see on your screen, we've got a tough one for you. The first poll question is a would you rather, so you get to select one of the 3 outcomes. Would you rather be stranded on a desert island with nothing to entertain you but a printout of the slides from today's presentation? Or would you prefer to be forced to play children's schoolyard games with your life on the line? Or would you prefer to be an employment lawyer in California? Now that last one, some of you are employment lawyers in California, so you're presented with what is a pretty direct sort of existential type question. But we'll give you a few moments to lock in your answers, and then we'll see among our audience which of these things they would prefer. For those of you who aren't in the know, the second option is a reference to a very popular Netflix series that's out there right now. I'm not going to tell you which one it is, but it's about a game and squid are involved.
And we're at about 50 or more % of attendees who have responded. So
we'll take a look at what our responses are. So in our audience, an overwhelming amount of you would prefer to have a printout of the slides from today's presentation. I think those of you who selected that must know what's coming down the pipe because you are about to see some pretty amazing things that you want to spend some time with. Not very many people want to be employment lawyers, which I think demonstrates that the audience was paying attention when Amberly was speaking earlier.
Yeah, absolutely. Yeah, not a totally unsurprising result, but good to know nonetheless. So, all right, as I mentioned at the beginning, we are going to have a short 10-minute or so break from substantive content before our next panel of speakers. So you can feel free to step away now if you need to, but if you want to stick around, we welcome you to do that too.
And for those of you who do stick around, we do have a little presentation to sort of fill the gap that we think will be both practical and useful. It may not help you comply with the law, but it is going to help you present your best self out into the virtual world.
Yeah, And some of us are going to need a little bit more help with that than others. But we all have gained a lot of experience this year by virtually attending some video conferences. No matter what platform you choose to use, it can be challenging to stand out from the crowd when everybody's kind of stuck, in their small box on a computer screen.
It's really true. And there are some tactics for looking good that are sort of obvious and well known.
Right, like using professional soft lighting and lip gloss to make your face pop.
Or putting the camera up at sort of a tall angle that makes you look a little less jowly, I think is the word.
Yeah, or making your co-host stand on, 4 reams of paper so that you can look a little less awkwardly tall.
Yeah, thank you for that, Brittany.
Yeah, you're very welcome.
But all of those are beginner tactics and strategies. And you come to these seminars because we're experts in the law and in presenting yourself to the virtual world. So we want to share some advanced strategies with you today.
Right. So first up, we want to address the virtual background. Not everybody can stand in front of a perfectly lit wall of foliage. So sometimes it can really help to throw up a virtual background. For example, you've probably seen The Simple Office.
That's right. It's elegant. This person seems pretty authoritative. But for those of you who joined us last summer, you may remember that we shared one advanced technique that really impresses during a virtual meeting. So with this strategy, you're going to take a photo. You're going to identify who the most important person in the meeting is. You're going to go out into the world, into the internet. You're going to do some quick cyber investigating.
Also known as stalking.
Right. And you're going to find some treasured family photos of that person. And a couple of mouse clicks later, and bam, you're there.
Yeah, you really can, though, take it a little too far sometimes. Yeah, see there? You took it too far.
Yeah, you're right. There probably are situations where you don't want to put yourself into a photo with the most important person, or maybe in their intimate, moments. And there are also going to be times where you want to make it clear that you are the most important person in the room. So, for example, here is Brittany very subtly indicating that she is very important. This is not a virtual background. This is her real office. And over her shoulder is a real photo. Now we're going to zoom in on that photo so you can get a better look.
Yeah, so that is a real photo of me and Lilibet, or Queen Elizabeth II, as you may know her. She's kind of like a third grandma to me, and it can be a little awkward to bring that up during a Zoom call. So I used to start most meetings by introducing myself as, hello, my name is Brittany Falkowski. I'm a labor and employment attorney with Husch Blackwell, and I am very close friends with the British royal family. But that did not have quite the impact that I was looking for. So...
yeah, so a quick and subtle placement of this photo, really does the trick. Now, how is the Queen holding up?
I think it's been kind of a hard year, but she's doing well. Thanks for asking.
Oh, that's wonderful. Now, for our next tips, we're going to address a very necessary piece of the video conference puzzle, and that is, how do you leave the screen for a break? So first up, a quick refresher on some tactics that we have been using for years. And the first one uses a background trick. Now, you take a photo of yourself, making a very good point, and then you copy and paste the spinning wheel symbol. And suddenly, you're not AWOL, you're just dealing with technical difficulties.
Yeah, the real problem with this tactic, though, is that it is now 2021, and employers are increasingly having this unreasonable expectation that employees have stable internet connections.
Yeah, you can't get away with this one for too long. Instead, you can try another strategy. Now, here you see me in a video conference, but I need to leave. So I very quickly hop out of the chair and swap in an indistinguishable body double. So it's perfect, right? And my body double actually knows a lot more about most things than I do.
Yeah, that's probably true. But the problem with this tactic is that it can take years to develop. And some people, only some though, might notice the subtle difference between you and your 4-year-old.
Yeah, that's true. I mean, at this point, I can only dream of having that hairline. Oh, where'd he go? There's my guy. And then there's another advanced strategy that we're going to recommend for you. So not many people know this, but virtual backgrounds don't have to be still photos. In fact, you can use videos. And I think they provide the best option yet for sneaking away from a meeting without being noticed. Take a look.
Meeting open. Welcome, everybody. We'll start with the apologies, and I guess we have Hazel. Everyone else seems to be here, I think. So could I have a mover, please?
Andrew, just before you do, I had to leave the meeting at 1:30 to attend a future-proof meeting, so sorry about that. So my apologies from them.
Good as gold. Thanks, Jim. So we include that in the motion as well. If someone would like to move, please.
Happy to move, Mike.
Thanks, Lou. Thanks, Susan. All in favour?
Aye.
Contrary, no. It's carried. Disclosure of members' interests. Do we have any today? No. I'll move on to item 4, late items. Any late items?
Yeah, that's perfect. You're going to have to teach me how to do that one.
Yeah, you may not have noticed it, but I actually left the screen during that clip and got some coffee and came back on. It was pretty subtle. But finally, we want to leave you with a quick sort of some tips on how to actually make yourself look better. Now, I'm not talking about diet or exercise. You know, those are things of the past. But one feature you may not know about is Zoom's Touch Up My Appearance tool. So yeah, that's right. In Zoom, you click sort of in the middle of the screen here, and there's a little toolbar, and you drag it, and it actually sort of dramatically improves your appearance. So for example, when I slide the bar to about 75%, I mean, wow, right? I mean, that's amazing.
Yeah, that looks great. How about when you move it all the way to 100?
Now, you know, you're going to want to be careful, right, about moving it all the way to 100, because when you move it all the way to 100, it changes you to Ryan Gosling.
Wow, you look really great there.
Yeah, no, I think I do. The facial hairs really come in. And, you know, so you're going to see what this looks like with Brittany as well. So, you know, here's Brittany with a little bit of the, you know, touching up her appearance. We give it a little bit more, right? That's even better. And when you take it to 100%.
I'm actually kind of excited to see this.
Yeah, you should be, because.
Ryan Gosling again?
Yeah, with this tool, all roads lead to Gosling. And our road now leads us to our next presentation, where we're going to hear from Eric Eisenman, Sunny Nolan, and Eric DeLay discussing COVID-related considerations.
That's right. So now we will send it back over to Eric in the studio.
Thanks, Brittany. Good afternoon, everyone. My name is Eric DeLay. I'm going to start today's discussion on COVID, focusing on government efforts to respond and improve workplace safety in the face of the pandemic. I'm going to hand it off after that to Eric Eisenman, the other Eric, to discuss legal vaccination issues. And throughout both topics, Sunny Nolan is going to give us some lessons learned and some of the advice and the experience that we've picked up over the course of 2021. So let's get started and think about the government response and the efforts. OSHA tends to be the primary agency that we think about as being in charge of the COVID relief effort or response for pandemic-related topics. But it's not the only agency that either has enforcement powers or has a stakeholder and an interest in workplace safety. The federal government is also an employer, and they are a customer for government contracts. And they have used both of those tools we've seen in recent months in order to try and continue to nudge and push the private sector toward vaccinations rather than just relying on tools of enforcement. The other aspect I would say, and I probably speak for Eric and Sunny as well on this, is if I had to describe how COVID and workplace safety have been addressed this year, I would say it's constant change. I think from an outside counsel perspective, I can say it's fascinating. If I'm thinking about this from a compliance standpoint, I might say it's exasperating or exhausting, because we have seen a significant amount of revisions, change, and evolutions in the policy and the initiatives that have taken place during this calendar year. If you keep in mind that the Biden administration came in on January 20th, and on the second day of the president's administration, he published an executive order directing OSHA to protect the American workforce by publishing guidance to mitigate the risk of COVID in the workplace, and then also directed OSHA to, by March 15th, decide if an emergency temporary standard or an ETS was required, and if it was required, to publish that standard by March 15th. As you may know, the March 15th deadline wasn't met. And I'm put on this slide several of the actions that we've seen and the changes that we've seen from OSHA's efforts just in the last 3 months. So in March, rather than publishing an emergency temporary standard, OSHA published a national enforcement program that looked at high hazard industries and had recommendations and instructions for employers in order to mitigate the risk. By the summer, we saw that the healthcare ETS was published, and this emergency temporary standard was focused on the healthcare industry and the unique sectoral risks that that industry faced. Once that ETS was published, then OSHA revised its national enforcement program. It also revised its March enforcement memo. And then in August of this year, it revised the January 2021 guidance that it published in compliance with the president's executive order. There are three concepts, though, that I did want you to think about or retain from those revisions, because these have generally held true throughout the administration. First off, retaliation or discrimination against an employee who raises a COVID concern or reports contracting the virus are prohibited. So that protection for employees has remained true. Then we look at record keeping. The guidance for employers is if you believe that you have had an employee that was exposed to COVID or possibly has a workplace illness, you're obligated to conduct a good faith inquiry to determine whether it is a work-related exposure. And if it is, then it needs to be recorded. The guidance from the agency has recognized that there are a multitude of ways from which a person can come in contact with the virus that may not arise in the workplace, and therefore the onus is on the employer to make sure that they have been diligent and acted in good faith as they conduct that investigation. In order to prevent any mixed message or discouraging of asking the workforce to get vaccinated, the OSHA guidance has also said that if there is a person that misses a day of work after receiving a vaccine, or if they have side effects that come from the vaccine, those are not recordable illnesses for the employer. Other piece that came out along the line of the retaliation and the whistleblowing aspect would be what I thought was interesting in September of this year is a change in the interpretation for whistleblower and the legal test for proving a whistleblower claim. In light of several Supreme Court cases that have taken place over the last few years, under the OSHA Act and Section 11C, for a claimant to prevail on a whistleblower or discrimination claim, it is now a but-for test on proving that but for the protected activity, they would not have suffered an adverse action. So the old ability to invoke a substantial reason test has been removed from OSHA's manuals. Not only do we have the federal OSHA requirements, but we also have state plans. There are 22 of them that are in place around the country. And right now, 14 states have published guidance that is either a permanent standard, such as Virginia, Oregon, and California, or temporary standards or executive orders that are all dealing with COVID-related matters. And I want to bring up the California one in particular, because if you recall in the earlier segment, Amberly mentioned looking at Cal OSHA as a indicator, so to speak, of where we may be headed on enforcement. I think she's spot on there. And part of the reason for that are the personnel choices within the Department of Labor. Julie Su was the former Secretary of Labor for California. She is the Deputy Secretary for the U.S. Department of Labor. Doug Parker is currently the head of California OSHA. He has made it through the Senate committee process and is awaiting confirmation by the U.S. Senate in order to become the next head of OSHA. So where California is on its philosophy is probably what we will see in part carry over to the federal sector. When we look at where we're headed next, I think, as we mentioned, that the federal government not only can be the enforcement entity that we have to worry about, but they are also a large employer and they are a very large customer within the economic marketplace. In September, the president issued executive orders that look not only at requiring all federal employees to have vaccines, but also for federal contractors that are working at federal workplaces to have vaccines. And the way that they are implementing that piece on the private sector is, as of October 15th of this year, new federal contracts or option years or extensions, and as well as leases, permits, easements, any of those aspects where the federal government is, in a sense, involved in a business transaction with the private sector, they will be requiring the employees of those contractors to be abiding by the vaccination requirements. There are 3 dates to keep in mind for that. October 15th is the effective date for new contracts where that would be applicable. As of right now, all federal employees are expected to have their vaccines completed by November 22nd. And for employees of federal contractors, the current deadline is December 8th. If you need information about the contracting side of it, I'd encourage you to go to the Safer Federal Workforce Task Force. And I realize that's a mouthful to say, but that is the entity that was created from the president's first executive order that is looking at workplace safety for federal employees. The vaccine mandate, this is an ever-evolving topic. And right now, I would say that we are looking at a question of whether it will be a hard mandate or a soft mandate. Even as of this morning, we saw the governor of Texas issue an executive order saying that they will not abide by the mandate in that year, or in the state of Texas. So it remains to be seen how that will pan out. The other aspect is going to be timing and implementation challenges. It may well be, as you've seen in the news, that several of the topics will be moot if most employers have already implemented policies for their own workforce. And I threw 3 examples up on the slide there to give you a sense of large companies seeing only about 1 to 1.5% of their workforce that are not complying with the requirements. So Sunny, I'm going to hand it over to you and let us know what you think, please, about the challenges that the employers are going to be facing in the months ahead.
Absolutely. Thanks, Eric. So you may have noticed the title of my part of the presentation, which we are interspersing in here, is Lessons We're Learning. You know, in the past, we used to say lessons learned. I don't think that's the case anymore. We are constantly learning. And as Eric mentioned, and they made it easy because everybody's Eric other than me. So if I can't get anybody's name wrong. But as Eric mentioned, the governor of Texas, having issued an executive order, I guess that was last night, saying that there won't be any vaccinations mandated in the state of Texas. What I find kind of interesting about that, just switch this over, is the fact that the EEOC actually has taken on Texas 3 times already, not the state of Texas, but employers in Texas. And we'll talk about that a little bit more later. One of the challenges that employers have already seen, and we will continue to see them, is the alphabet soup and how that all works together. And what I mean by that is the CDC, the EEOC, OSHA, ADA, the CARES Act, all of those things trying to work together. Then you throw in FMLA, you throw in some state regulations. It makes it very difficult for any employer, even an employer only in one state. It makes it very difficult for them. Right now, there are 7 states that require masks indoor, regardless of vaccination status. There's a couple of territories, so I get calls all the time from employers. In fact, one this morning was like, what do we do about this mandate, from President Biden? They're located overseas. I'm like, well, let's hold on for another minute. Lesson learned or lesson learning, number 2. And we mentioned this a little bit earlier. Amberly mentioned it, and Eric has gone over it a little bit, but we are probably going to see some class actions, PAGA class actions in California. And what I mean by that, and this is about the health safety violations can lead to liability, is because citizens can enforce the laws, and there are lots of different laws in California related to safety. We're likely to see, whether it's legitimate or not, we're going to likely see some of those pretty quickly here. So one of the questions is who's supposed to be the mask police in those areas where masks are required? For an employer, this often falls to HR, and HR is tasked with a lot already. One of the things that HR doesn't want to do is also walk around the halls and ask people to wear their masks. What I have been recommending, and my colleagues have been recommending, is giving managers some FAQs. We have written more FAQs in the last year than probably the last 10 years, right? And basically, that's going to help HR. If you give managers things to say when employees have questions, or employee FAQs, for example, so those questions are answered, they have somewhere to go, that's really something that can be helpful to you. The next one. So lesson learned number 3. There are lots of things that you're going to have to talk to the union about more than ever. Unions are requiring negotiation over workplace changes specific to COVID, whether that is taking time off for a vaccine or changing the benefit plan, the surcharges. If you negotiate those, typically you're going to negotiate them in this context, regardless of what the state law requires. You're still going to be obligated to negotiate. I had an employer just the other day say, well, we've never had to negotiate on safety, but do you pay for the safety boots? Yes, we do. So are you going to be paying for testing? Well, the union's going to ask probably for you to do just that. One of the other things that we've seen a lot is the social media, where we're talking about social media a lot lately, for sure. But what do you do when you see your employees online criticizing the company over their vaccination program? We've seen that. What we have typically said, one, you don't really want to get involved in that, particularly if it's a unionized workforce, right? But two, if you engage, it's likely just to escalate it. So again, I would look to your communication people, not engage online. But the other question is, what do you get when it's online and it's a lack of a safety program? We've seen that to really pressure employers to have a mandatory vaccination program. A lot of employees don't want that, but a lot of employees do. So when the criticism comes about a lack of a safety program, I think a lot of employers, based on their clientele especially, feel like they need to do something related to that. And when they do decide to have a mandatory vaccination program, you want to do it right. And Eric's going to talk to you a little bit about that.
Great segue, Sunny. Thank you. We've talked a bit about the what may or may not happen in terms of a federal mandate. But regardless of what happens in that context, you are going to have to deal with various legal issues as they relate to vaccines. I've got a list here of some overview of items that I think are keeping employers up at night as it relates to vaccines. The first bullet point there, EUA, Emergency Use Authorization. This is something we heard a lot about earlier this year before the Pfizer vaccine, for instance, was authorized for emergency or for approved for use. But the two other vaccines, Johnson & Johnson and Moderna, are still authorized under this emergency use authorization. There was a question about whether an employee has the right to reject a vaccine or could object based on that status. The short answer, as you probably know by now, is that there have been no successful legal challenges on that basis. So the fact that a vaccine is authorized under that EUA classification does not exempt an employee. Title VII, we'll talk more about that in a couple slides, but obviously there are obligations not to discriminate on the basis of religion under that law, which can apply for vaccines. The ADA, our obligation not to discriminate on the basis of disability, that's implicated in this context. Eric D. talked about the Occupational Safety and Health Act. That's obviously a law that's implicated, can create liability for employers. That federal standard that Eric talked about is something that's clearly on your radar screen. State law. This is the absolute every end of the spectrum, right? We have some states, New York, for instance, which is implementing its own vaccine passport to allow individuals to go to restaurants and bars. On the other end of the spectrum, we have what my partners here referenced, Texas, taking this aggressive action by executive order, suggesting that vaccine mandates are not going to be permissible in that state. So you can expect the full gamut based on where you operate. I will say on this point, and this may not be new news for you, but currently there is only one state, and that is Montana, that has issued through the legislature a prohibition on vaccine mandates. There is pending legislation in a number of other states, but that's the only state right now that we've seen it illegal for an employer to mandate vaccines. Stay tuned for Texas. Stay tuned for a couple other jurisdictions where we think we might see that activity. And then the final bullet point here, civil liability or workers' compensation liability. If I have an employee who gets sick, do I, as the employer, have exposure for a claim that individual might bring? In most instances, if there is that kind of exposure, it would fall under the workers' compensation framework, and your workers' compensation insurance carrier would be covering that claim. But we can envision a scenario where a creative employee might try to make a civil claim to try to bring those claims for additional damages. Another reason why it makes sense for you to tread carefully in this area. Talk briefly about this ADA consideration, right? What the law requires is that you as the employer not discriminate on the basis of disability. So you have an employee, you implement a vaccine mandate, you have an employee come, request an accommodation based on a medical reason, based on a disability. What are you looking for as the employer? Typically there, you would be looking for information from the employee and potentially from her doctor, indicating that she is unable to receive the vaccine because of a medical reason. okay? Once the employee gets over that initial threshold, the second step that you as the employer will assess is whether accommodating that request would create an undue hardship on you as the employer. In most instances, it's going to be difficult for you as the employer to demonstrate that undue hardship under this ADA framework. We'll talk in a second about the Title VII religious framework, which is going to be different. But here in most instances, if you have that doctor's note, the employee has identified a disability, you're likely going to have to grant that accommodation. That last bullet point, if the employee poses a direct threat to the workplace, again, there's been a lot of discussion about whether having an unvaccinated individual in a workplace, maybe where they're interfacing with clients or customers, could meet that standard. But my big picture takeaway here is that I think you need to tread carefully if you're thinking about denying accommodation request on the basis of disability. And how does that fit in with a discussion of culture, Sunny?
Absolutely. Thanks, Eric. So culture. One of the things that I've been talking a lot to employers about, I think we all have more than ever, is the company's culture. The reason that's important, it helps inform what kind of policies the employer is going to adopt. And on the screen here, on your screen, there are at least 4 considerations that you will take into account, and that would be your clients and the makeup of your workforce and the industry and the geography. One of the things that I think is really critical when you're looking at culture is taking this opportunity to look at your policies, for example. The fundamentals, we are back to fundamentals, right. But that is one of the things that is going to help. I'll give you a couple quick examples. One, we had an employer who had an employee kept taking COVID leave, paid COVID leave, but then wasn't quarantining, was working a second job. That employer did not have a policy regarding working or quarantining when they're taking, basically quarantining paid leave, and this person kept doing it. So they had to have a policy on that. Looking at a social media policy. There are a lot of different policies that employers really should be looking into right now. Eric touched on the accommodation process already related to medical ADA, but one of the things as we are helping employers implement, frankly, some don't have any processes in place, because that's the other thing. You really need to look at your processes to help HR. One of the issues that a lot of HR professionals have brought to us is the fact that they've never really dealt with any sort of religious accommodation issues. And I've only had 1 lawsuit, really, maybe 2 in 20 plus years of doing this. We are all having to look every day, what is the EEOC bringing forward? One of the things that employers should be on the lookout for is whether the long haul effects from COVID, and that means those lasting effects from COVID, if that they're saying that's going to be considered a disability, so we're going to look for some guidance on that. One of the things at the outset of COVID-19 was employers were concerned, is work from home always going to be considered a reasonable accommodation for whatever reason, a disability, religion, or otherwise. And we are seeing that the EEOC has filed a lawsuit related to this. But to avoid, hopefully, all of these things, because there is no magic bullet, we want to make sure that the employers that are tuned in today understand how to deal with these accommodation requests. A little bit about that.
Great. Thank you, Sunny. Really great points there that Sunny just made. The 2 things. First, there's no magic bullet. Husch Blackwell's good, but maybe we're not the magic bullet. And second, that there is no one-size-fits-all. I thought that was a really important point that she made. We're advising clients, and like she said, if you're a client located in a particular geography, or you service a particular industry, or you have a specific kind of workforce, your decisions in this space might be different than another one. And that's okay, unless and until we have more clear guidance here. But let's talk about that religious exemption request that Sunny ended up on, because this is very much top of mind for the employers that we're talking with, okay? There's a similar analysis here that we saw in the ADA context. The law prohibits discrimination based on a sincerely held religious belief, and it requires the employer to grant an accommodation unless they can demonstrate an undue hardship. But here's one thing I want to highlight for you. The language that is used in the law, this undue hardship analysis, is the same. It's a different test. It is easier for an employer to demonstrate a undue hardship in the context of a request for a religious accommodation than it is a request for a medical accommodation. Under the case law that's developed, an employer can demonstrate that it can deny a request if it can show that it would create more than a de minimis cost to accommodate an individual who's requesting a religious accommodation. And here's why this is particularly relevant. If your business is anything like the ones that we've been talking to, you are noticing an increase, a proliferation of what I'll describe as cookie cutter religious accommodation requests. You're seeing requests that look like they might have been copied and pasted off the internet. A lot of them are using the same language. Now, simply because that may be the case doesn't mean that you can reject it out of hand, okay? I've got some language here. I probably have too much text on this for the slide if the PowerPoint experts would tell you here, but I thought it was important to include. Sincerity of a religious belief is generally presumed. Inquiries into that sincerity are not supposed to focus on the motives or the reasons for holding the belief, but rather it's a matter of the employee's credibility. So can I test that credibility if I see something that looks to me like it was copied and pasted off the internet? The employer has the right to engage in that interactive discussion with the employee to verify, okay? And based on that process, the employer may also request limited additional information. So what we've been crafting for our clients are forms that they can use to appropriately ask for that additional information. If an employee requests that kind of accommodation, here are the different sort of questions that you can ask. Have you previously received vaccines? You know, when did you come to this religious belief? Because employers, again, some of them are finding themselves inundated with these requests, and they want to have a plan of some kind to be able to assess which ones are bona fide and they're going to grant. Similar to this religious accommodation request, there's also a question about whether in some states an employee has a right to object to a vaccine based on a right of conscience law. Some states have these laws, and really what these were developed for over the last 20-ish years were laws that would allow individuals in certain industries, largely in the healthcare industry, the ability to opt out of performing certain medical procedures or providing certain services. So to provide a healthcare worker the right not to participate in an abortion, for instance, if they believe that that violated their right of conscience. What we are seeing now, Illinois is on the front lines of this sort of theory, is employees invoking these laws to avoid having to subject themselves to vaccine requirements. This is unclear. It is not clear to us yet whether these are going to be successful challenges, but this is a new frontier where I am anticipating that going. Finally, one thing that I'm getting a lot of questions about these days, and you may as well, employee comes to you and says, hey, you've implemented a vaccine mandate, but I had COVID. And in fact, I have an antibody test that shows that I have robust immunity just as someone who had been vaccinated. Do you as the employer have the obligation to honor that or allow that employee to opt out of a vaccine requirement? The science on this, I think, is still a little unclear. There is a study, an Israeli study that we see cited, suggesting that the natural immunity can be stronger or more robust than the sort of immunity that you would develop as a result of the vaccine. But the CDC guidance on this point suggests that a vaccine even provides additional protection for those who have already had COVID and have the antibodies. In addition, this natural immunity seems like it varies from person to person, and it's difficult for us to determine exactly how protective that is. So my takeaway is that I think it's unlikely in the short term that an employer is going to be obligated to grant an accommodation in this context. I have the question here, will the OSHA ETS or the Biden administration rules account for the consideration? We think the answer is no. Finally, if you're going to have this accommodation where employees are going to be able to engage in testing instead of having to submit to the vaccine, who pays for it? The estimated median cost here is about $148 a test. Will the OSHA ETS address that? If not, state law is probably going to apply. A number of states, including California and Illinois, require employers to reimburse employees for job-related expenses. And there's some other considerations here when we talk about testing. Is the Fair Labor Standards Act going to apply, Sunny?
Exactly. So in addition to, and we are getting this question, I don't know, maybe every week at least, before it was just about every day, around reimbursement. And I think people are paying attention to reimbursement related to vaccination. And like Eric said, it will be a matter of state law generally, or at least it is right now. But some of the other FLSA issues may have escaped as much attention, as much spotlight. And that brings us to lessons that we're learning, lessons 6 and 7. And they're both about FLSA. One, reimbursing for work from home. We've gotten that question a lot, hence the WFH. I'm not sure we all knew what that meant previously, but we all know what it means now. That's not going away. Back to that culture issue, you're going to see a lot of work from home. As employees are moving home, do you have a policy in place for work from home? Whether it's a safety policy, what if someone gets hurt working from home? But the thing that we're seeing the most is the reimbursement for the paper, for the mobile phone that they're required to use, and in some states, Wi-Fi. And Eric mentioned a couple that are always on our radar, California and Illinois. They're very robust in this area. But South Dakota, North Dakota, I have not really dealt with them that much, but I have been in this context. The other issue that I want you guys to be thinking about is the exemption status issue. This really was highlighted recently for one of our clients who brought up the outside sales exemption in California. And there's some belief that the exemption status based on the job change. Okay, so the job was changed when the outside salesperson started working from home. They're no longer considered really an outside salesperson. Are they exempt? So that was a pretty scary one. Still is. We're not sure where that's going to land, but we all need to be very careful when we're looking at sending people home, what policies we have in place to support that. The other thing I would say is job descriptions. Julianne, who will be up in just a moment, she mentioned this to me. Job descriptions were always an issue, particularly for work from home, for example. You probably need to put that in your policy. If people need to come into the office to do their job, or if they need to travel, these things are not going away. If travel is required, start looking at your job descriptions. Let's make sure that they are actually, mirroring the reality that we are living in today. And okay, so I say, get ready for the new normal. And the reason I said that is because I'm tired of hearing about the new normal, because that seems to be every 6 hours there's a new normal. So there is no new normal. As Eric already mentioned, depends on what kind of employer you are and where you do business and who your clients are. But there are a lot of things that are not going away, and we've talked about those a lot. Work from home, that's not going away. Video conferencing, that's not going to go away. We aren't doing as much travel as we used to do. We used to do depositions all over the country. I'm doing them from my living room most of the time now. So you should expect that that's not going to go away, and you need to have policies and processes in place to support those realities. We mentioned this already, prioritizing the fundamentals, the job descriptions, having those processes in place, having policy support. So you have something to point to say, hey, we can't do exactly that. And the last thing is talk a little bit about litigation trends. So I don't think anyone's surprised to know that remote work and leave, those are the top 2 issues that are being litigated. Most of the cases, yes, they are in California, but if you control for population, New Jersey actually is the top. And in the top industry was healthcare. I was really surprised by that. I guess I just assumed that healthcare would sort of go along. Manufacturing falls below 10%. Retail is the next. So I think that's wraps it up for us, and we will turn it back over to AJ and Brittany. Thank you for your time.
Great, thanks, Sunny. And welcome back, everybody. We are now taking our second break of the day, which is going to last again about 10 or so minutes.
And for those of you who stay, we will be playing one of our favorite games that we call Bluff the Audience. For those of you who have attended some of our live events in the past, this may be familiar. The rules of the game are pretty simple. So basically, you're going to hear 3 stories from Husch Blackwell attorneys, each of which will be about a creative employer incentive that came out during this pandemic. Only one of the stories that you're going to hear will be true. And then you at the audience will have a chance to separate the fact from the fiction. And each of you who gets the answer correct will receive a special prize that we'll reveal at the end of this break. So the first story that we're going to hear today is from our colleague from Chicago, Sarah Quinn. Let's join us, Sarah.
Deakins LLC is a 3D printing and modeling startup in Boulder, Colorado. Its success relies on fast-paced customer turnarounds, in-person collaboration, and the use of high-powered technological solutions that simply cannot be replicated at home, so its employees returned to the office earlier than most last year. But Deakins' workforce of mostly 20-somethings has been slow to get vaccinated, and leadership wanted to increase those numbers to make the return to office more palatable to employees with health conditions. Leaders considered instituting a vaccine mandate, but worried it conflicted with the concepts of personal responsibility that they had baked into their mission statement. They rejected using a vaccine incentive because, like a lot of startups, they didn't have any money. Still stuck on how to get more of her employees stuck, CEO and founder Cheryl Deakins found inspiration right where you'd expect it, a documentary on former Panamanian dictator Manuel Noriega. As the US military ousted Noriega from power in the late 1980s, he famously took refuge at the Vatican Embassy in the Panamanian capital. Unable to enter the embassy, US troops forced Noriega's surrender by setting up loudspeakers that played rock music nonstop at deafening volumes. The playlist was not subtle, including hits like Give It Up by Casey and the Sunshine Band and No More Mr. Nice Guy by Alice Cooper. Cheryl had her answer, and all it cost the company was $1.29 on iTunes. The next day, without explanation or warning to her employees, Cheryl connected her iPhone to the office-wide telecom system and hit play on the radio edit of Shots by LMFAO featuring Lil Jon. You know the song. It's the one with the sophisticated chorus that goes, shots, 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 everybody.
Oh, I'm sorry. I zoned out there for a second. Could you repeat that?
Yeah, I'm not going to sing it again. But just the word shots like 20 times and then everybody. Anyway, Cheryl played the song on loop, hoping the subtle message would get across. One Deakins employee explained the effect to the local newspaper. Quote, on the first day, it was kind of fun. People were dancing and laughing along and calling it the Deakins Club. The second day, the novelty was gone, and we would groan every time we heard the song start over. The third day nearly killed me. I heard the song even when I was away from the office. I dreamt about it. I couldn't hear a word that rhymed with shot without flinching, and that's tough because my name's Scott, unquote. At the end of the third day, Cheryl sent a company-wide email that was blank, other than the phrase 90% with a question mark in the subject line. The next morning, employees arrived to find a mobile vaccination van parked in front of the building. Just after 10 that morning, the music stopped.
Thank you, Sarah. All right. And with our next story, we have another of our colleagues. This is Kate Copen from our St. Louis office.
Welcome, Kate. One moment. AJ said I had to step on at least 3 reams of paper so that he looked less awkwardly tall.
Thank you.
So, like many of us, the employees of Zebra, an insurance comparison website based in Austin, Texas, were feeling lonely while working from home during the pandemic. There are a number of options for trying to cope with that loneliness. Doom scrolling social media, binge watching Netflix, gorging on unhealthy foods, pretending to be busy to avoid weekly Zoom calls with extended family or coworkers. Those are just some of my favorite tactics. But they may not be enough for all people, and Zebra's CEO, Keith Melnick, decided to help his employees fend off loneliness with a companionship on 4 legs. In a first-of-its-kind perk, Zebra has incentivized its employees to adopt a new furry friend by offering a $300 annual stipend if they adopt a new dog or cat while working from home during the pandemic. And Zebra has gone a step further, offering paid time off for the employees to bond with their new pet. Not surprisingly, the stipend and paid time off, which the company has dubbed paternity leave, have been popular. One Zebra employee, Mary Belize Ortiz, used the benefit to bring home a new dog. Explaining her decision to adopt, the 27-year-old Ortiz said, "I'm not ready to have a child anytime soon," which is the same thing that a lot of 27-year-olds have had to say while answering way too personal questions on their weekly extended family Zooms. Ortiz added that it feels really nice to be supported by my company to help start a family in the way I can right now. Not only that, I have seen the pictures, and in my opinion, her new miniature long-haired Dachshund named Nico is objectively way cuter than any human baby that has ever existed.
You haven't seen our kids then.
Speaking of my opinions, I think this program is good, but it could be better. Why, for example, is the leave limited to just dogs and cats? $300 per year would buy an awful lot of guinea pigs. And think of how much time and attention it takes to really bond with a goldfish that you can't safely snuggle for more than a few minutes at a time. But really, this feels like a missed opportunity to tie this promotion into even more publicity for the company. The company is called Zebra, after all. The obvious and better move would have been to send its employees service animals of the black and white striped variety. You may not know this, but it is perfectly legal to keep a zebra as a pet in most of the United States. Sure, experts say zebras are difficult to train. They constantly try to escape, and they have a kick that can kill a lion. But wouldn't you still prefer all of that to another Zoom call with family or coworkers? I know I would.
Thank you, Kate. And since this is a legal presentation, we should note, check your local laws in with an official exotic animal attorney before adopting a zebra. But with our last story, we're going to move to my co-presenter, Brittany Valkowski.
All right. So when the pandemic caused industrial supply company Amerifast Inc. to abruptly send its employees to work from home in March of 2020, its call center in Spartanburg, South Carolina, was left looking like the lost city of Pompeii after Vesuvius erupted. Half-full mugs of coffee left in cubicles, plastic utensils strewn around a birthday cake that was missing 3 of its 4 corners, piles of half-completed paperwork sitting next to quarter-completed crossword puzzles. When office manager Sean Lytle first returned to the office a month later, he discovered the sudden absence of people had just decimated the indoor plant population. But the many snacks left behind were a boon for the office's previously unseen and always unwelcome inhabitants, cockroaches. Sean saw dozens of the insects running wild across the office. While Googling yesterday, I actually found an anonymous internet comment from someone who is almost definitely a cockroach expert. And that person said that for every cockroach you see, there are over 100 hiding in the walls. In other words, Amerifast had a problem. But Amerifast prides itself on creative problem solving. And in that spirit, Sean sought a novel solution for their cockroach infestation. He considered bringing in snakes. He thought about burning down the building.
Reasonable.
But ultimately, he decided to hire Davis and Davis, a father and son pest control company, and Sean promised them a $1 bounty on every cockroach they killed. Pursuant to the terms that they negotiated, on the first day, Sean received a video of the Davises holding up a copy of that day's newspaper and then lining up and counting over 200 dead, creepy crawlers before throwing them into the building's incinerator. The next day, nearly 400 cockroaches met a similar fate. The third day, another 500. Sean was pleased. His idea was working, and he happily paid those hefty bounties. Now, a quick note of you for those issue spotting at home. Because the Davises were hired as independent contractors, Amerifast did not have to deal with the difficult question of whether cockroach bounties have to be included in an employee's regular rate of pay for overtime purposes.
I was wondering.
Figured you were. So as you would expect, the daily numbers sort of leveled off before dropping down to just a few cockroaches per day. And then something really weird happened. The numbers spiked, even higher than before. The Davises started sending videos of 800, then 900, then 1,000 cockroaches. Sean was confused. Why were there suddenly so many more? After all, he was pretty sure he had thrown that cake away. So he went to the office to investigate. He walked the call center floor, no cockroaches. He checked under desks and in hallways, no cockroaches. He didn't even see any cockroach traps. How were the Davises possibly killing 1,000 cockroaches in a day? Sean next entered the custodial office that the Davises were using as their on-site headquarters, and he got his answer. The office was filled with large glass terrariums stacked floor to ceiling, each with a water dish, a heat lamp, and a bowl full of scraps, and each teeming with cockroaches. I get the shivers just thinking about it. Yeah, according to court filings that made the news last month, when Sean confronted the Davises, they left the office, but not before releasing those cockroaches. In their counterclaim alleging breach of contract, the Davises aptly pointed out that the bounty agreement did not specify that the cockroaches had to be wild. The lawsuit remains pending, but the fate of the cockroaches unknown.
Yeah, that makes me very uncomfortable, but thank you, Brittany. All right, so you've now heard our 3 stories, first from Sarah Quinn, then Kate Copen and Brittany Falkowski. And now it is your chance, audience at home, to decide which of those 3 women were telling you the truth. So we'll go to our poll question. It's our second of the day, and this is your chance to lock it in. Which is the true story? Was it Sarah's story about shots, and then a bunch of more shots?
Everybody.
Was it everybody? That's right. Was it Kate's story about Zebra, the insurance company's Zebra-less incentive program for paternity leave? Or was it Brittany's story about pest controllers that turned themselves into profitable cockroach farmers? So we'll let you all take some time to think through which one you think is true. Now understand a special prize is on the line, so you want to take this very seriously. And we'll give you some more time to decide. I have not seen a cockroach since we've been back in the office, which I think it's a positive reflection on how effectively we finish birthday cakes at this office, I think.
Yeah. My plant, though, decimated.
Did you lose your plant?
I did.
Yeah. I think that's been common. So I think we're up to about 50% or so. We'll give another moment or two, and then we'll find out how you did. So the audience is unbelievably evenly split. When this pops up there, you're going to see nearly 30% to each of the 3 stories, which I think is a reflection of the fact that 2 of our 3 people lie very effectively. And so to tell you which is the true story, we'll do a dramatic reveal of a photo of one of the pets that was adopted pursuant to Zebra's paternity policy. That is Nico, the miniature long-haired dachshund. And it is fair to say that that is cuter than either of my children were as babies. So thank you. Congratulations to everybody who got it right. Thank you to our participants for reading the story. I mentioned there was a special prize. And for those of you who guessed it right now inside of you, you're likely feeling self-worth and an increased sense of being better than the other participants. And that's your prize. And that's no charge. So we're going to move on now to our final presentation of the day.
Yeah, we're going to have Julianne Story, Barb Grandjean, and Anne Mayette, who will be exploring the increasingly complex role that gender is playing in our workplaces. So go ahead and take it away, Julianne.
Thank you very much, Brittany. Hello, everyone. I'm Julianne Story. Prohibiting employment discrimination on the basis of sex, which is the language used in the federal employment statutes, seems like a pretty straightforward concept. Yet, courts and legislatures have struggled with the meaning of that phrase since the 1960s. Barb and Anne and I are going to talk about 3 different topics to shed some light on the meaning of gender in the workplace. Barb's going to talk about pay equity. I'm going to talk about pregnancy discrimination, and Anne will close us out with a discussion on gender identity. Barb?
So I'm going to talk about the continuing evolution of pay equity. And I'll note, Brittany and AJ, that we didn't expect to be following a cockroach story. So hopefully sex is interesting enough to keep people motivated to stay through the end of our program. So pay equity, we start with the Equal Pay Act of 1963. And this was an amendment to the Fair Labor Standards Act to add as a prohibited basis of pay discrimination, paying someone differently on the basis of sex. So this is 1963. This is the year before Title VII in 1964, where we're most familiar with the on the basis of sex language. Unfortunately, this Equal Pay Act hasn't been as effective as we might like to see. And I think that's in large part due to the second highlight I have here on this slide. There is an exception to a pay disparity between opposite sexes if that differential is based on any other factor other than sex. And so that exemption is so big it almost swallows the rule. And so Equal Pay Act cases aren't really all that active or effective in correcting a gender pay gap. Congress has tried many times with the Paycheck Fairness Act to try to close this loophole or at least limit it to make it more of a job-related business necessity type of a test. But so far, that has not been successful. So every year we celebrate or we recognize or we remember Equal Pay Day. And Equal Pay Day is the day in the year that a woman has to work in order to make as much money as her male colleagues made in the prior year. So as of March 24th of 2021, on average, a woman who makes 82 cents per dollar compared to a male, she has earned as much as the male did in 2020. It's a sad commentary. It continues. It's a bigger pay gap for women of color. And the COVID-19 pandemic has really, I think, thrown a wrench into moving forward with pay equity really at all. This is a message from the chairperson of the EEOC, who is predicting that the pandemic is actually going to have another 5% decrease in achieving pay equity due to all the things that women have had to deal with during the pandemic, women in particular as caregivers. So in part due to the failure of the federal government to be able to come up with something that would effectively try to mitigate pay equity disparities between or on the basis of sex, the states have started to fill in the gap. And this has been happening for a number of years. It's similar to what we see in the paid sick leave. Unless or until there is a federal paid sick leave requirement, the states are all doing their own thing. So what we've done is gone through a number of the state statutes. This is not scientific, but we've tried to pull out some of the features that we're seeing in the pay equity statutes that are hopefully going to be moving the needle. The first one I'm calling concerted protected activity, and that will sound familiar to you if you've spent any time with the National Labor Relations Act. But essentially under that federal act, employees in union and non-union environments are permitted to get together and discuss and complain and otherwise commiserate about the terms and conditions of their employment, and that includes pay. So we've all always understood that you can't prevent your employees from discussing pay with each other. The state statutes take it a step further. Under many of the different state statutes, you can't discipline, you can't retaliate against somebody, you can't prevent people from discussing their pay with each other. There's a list here of some of the statutes that do that. It's not a scientific list, it's just some examples. And the one caveat to that is that I think there's still, under most of the statutes, is an argument that if you have access to pay information related to other workers in the workplace, not just yourself. So for example, you're an HR person, you're still going to be prohibited from discussing pay information belonging to other people, and that would be an exception to the statutes. The flip side of the concerted protected activity, which means employees can talk with each other about their own compensation, is what is called a salary history ban. So in many of the state and local laws, the employer is not permitted to ask an applicant for employment about their salary history. How much did they make at a prior job? How much have they made during their history? Those kinds of questions are generally prohibited.
Barb, let me stop you for a second. What about well-intentioned employers who want to make sure that they're giving a candidate a competitive offer? Is there any leeway on what they can and cannot ask?
Well, so the answer to that question is not really. These statutes, regardless of the employer's motivation for asking the question, prohibit the employer from inquiring into salary history. Now, I think there's a way to do that that wouldn't run afoul of these statutes, and that would be to ask the applicant what their desired pay range is, or where they might like to end up, or what they're hoping to have an offer be. But I would suggest that even that workaround is probably not going to be all that important. In a few slides, we're going to talk about pay transparency provisions that we're seeing in more and more of these statutes. And under those pay transparency provisions, the employer needs to be letting the applicant, it varies, but the employer needs to be saying up front, here's how much I'm willing to pay for this position. So the question of whether how much the applicant wants for the position is going to be mooted, I think, by the employer saying, here's what I'm going to pay. And if the applicant doesn't like that, they'll be moving on. I think it's also important to remember that the salary history ban, what the employer cannot ask about, relates to the wage rate. So it would be all compensation, including commissions, bonuses, any other kinds of things. And an employer should not be asking an applicant about those types of things. Another newer development that I think is pretty significant is what I'm calling Pay Data Reporting Plus. And I know Amberly talked about the California statute in one of the earlier presentations today. I want to talk a little bit about the Illinois statute. So in Illinois, starting next year, employers have to provide a variety of different information to the government about race, gender, job descriptions, but also about pay rate and hours worked, so that the government's going to be collecting information about pay for the workers. In Illinois, employers are also going to have to seek and receive an equal pay registration certificate. There are a lot of words on this slide, but it describes that certificate. And essentially, there is a representative of the company that has to certify that they're probably in compliance with the state Equal Pay Act. And that's a regular certification that needs to take place. And so I think what leads up to that is all kinds of work on the behalf of the organization and the person that needs to certify to that to say that there are, in fact, no real pay disparities. And I thought we have Ann here from Illinois. If you could just tell us how employers on the ground in Illinois at least seem to be reacting to that.
Yeah, but I would say employers on the ground right now are confused. There have been amendments to the requirements. The government is now saying they may give you notice of when you need to get your equal pay registration certificate, but they may not. And that is not per se an excuse for not properly reporting. So there's confusion, and I think employers are uncomfortable with the confusion surrounding this act and what they need to do and be able to accurately certify at this point.
And this also applies to employers that with more than 100 employees, so it's larger employers at this point in time?
That's correct, yes.
Yep. Well, I think it's interesting. We'll see if other states start to follow suit, but Illinois, as in many things, is a leader in this area. Another set of provisions that we're seeing in many statutes relates to pay transparency. And so these vary across the states. The questions of who needs to be made aware of what the salary range may be and when in the process. So is it a particular applicant? Is it a particular applicant who has completed an interview? At what point in time does the employer have to disclose that information? And that makes sense to me that as part of that process, you would learn about compensation issues for the job you're applying for. I'm here from Colorado, so I wanted to talk a little bit about the Colorado, I called it model on this slide, but it's really a Colorado experiment. So different from California and Illinois, if you have even one employee working in Colorado, you are subject to Colorado's pay transparency laws. Those laws require you to post any job openings anywhere in the company internally for your workers in case they would like to apply for those positions. And they also require you to post internally and externally the range of pay that you are willing to pay for a job that can be performed in Colorado or will be performed in Colorado. So when you're posting that information, it means your competitors are seeing it. It means all of your workers see it. They see what the new HR generalist is going to make when he or she is hired. And that's created a lot of unintended consequences, I think, and disruption in the workplace. We'll see Colorado's out there in front, even in front of California on this one, and we'll see if other states follow suit. Another thing we see a lot of is audits. And so in Colorado, at least, that's a partial defense to some of the liquidated damages under our equal pay statute. I think it's essentially a requirement under the Illinois statute that we've talked about. I'm not sure how you can do a certification without doing an audit. An audit is really, in my view, a best practice that companies should be following. It's a risk mitigation tool, of course, but I think it's also an employee retention tool. People want to know that they're being paid fairly. And if the company is able to say that we've done an audit and we've assured them that that's the case, you're going to have better luck, I think, with retention.
I have another question, Barb.
Okay.
For those employers who want to be proactive, even if there isn't a legal requirement for them to do an audit, what recommendations are there for those who want to be self-critical, gather data and analyze it to measure how they're doing, but they're concerned about the discoverability of that kind of information if there's litigation resulting from a unfair pay claim?
And that's exactly right. And I think the best answer to that really is involve counsel, inside counsel, outside counsel. You want to do this audit no matter how formal or informal it is, under the guidance and direction with the supervision of legal counsel. So you have the attorney-client privilege, you can really analyze the results, you can make your changes, and then when you're ready, when your data is ready, when you feel like you've fixed what you need to fix, then you can release the results, but at least having them under the cloak of privilege protects the process. My second caveat here is that if you're not going to do anything about pay disparities that you find, don't bother to do an audit. It's worse to do an audit, find out that you have problems, and then not actually do anything to fix them. Litigation, of course, is a tool we see in a lot of the statutes. These cases are settlements and other resolutions that have taken place really just over the last 6 months. Syracuse University is the big number there at $3.7 million. That was 5 professors who believed that they were underpaid. And the settlement reflects that that may actually have been the case. So my final slide is things to be thinking about doing now. You need to know which of the pay equity laws are applicable to your business if you're a multi-state employer. And as we have so many remote workers, do you know where your remote workers are? Do you have a remote worker working in Colorado such that you're subject to the Colorado pay transparency laws? You should be reviewing all of your forms and policies, your interview guides, your applications, your confidentiality agreements. You're looking for bad words. If you have a confidentiality agreement that says that someone's compensation or salary is confidential, you may be violating one of the concerted protected activity type provisions that I'm talking about. You should be conducting regular audits. And then I think finally, what you should do as an employer is have an open door and an open mind. A lot of these pay equity claims come up when somebody feels like they're not being treated fairly. And if you have a process for hearing them and for figuring out a way to make them feel better about how they're treated, you may very well avoid pay equity claims. And so that's really your best cure right there, is just to listen and try to react in the moment and not wait till you get sued over it. And with that, I will turn it over to Julianne, who's going to talk about pregnancy and on the basis of sex.
Thank you, Barb. I think it's going to be helpful to understand where we are, to turn back the clock and understand where we started. Title VII of the Civil Rights Act of 1964 provides that it is unlawful for an employer to discriminate against an individual on the basis of race, color, religion, for today's purposes, sex, or national origin with respect to certain employment decisions and actions. That does not seem like a very controversial subject, but historians have speculated that the term sex was added to the legislation in order to defeat its purposes. That being said, the law did pass after vigorous debate. 12 years later, the United States Supreme Court rendered its decision in a 1976 case, and the court found that GE's disability plan, which explicitly excluded coverage for any absence due to pregnancy, did not violate Title VII. Well, very shortly thereafter, only 2 years, Congress, in direct response to the Supreme Court's decision in Gilbert, passed this Pregnancy Discrimination Act of 1978. And the Pregnancy Discrimination Act, or PDA, amended Title VII to specifically clarify that on the basis of sex includes, but is not limited to, pregnancy, childbirth, or related medical conditions. The Pregnancy Discrimination Act also requires that women affected by these conditions are treated the same for all employment-related purposes, including benefits, a direct reference to the Gilbert case, as other persons not so affected, but similar in their inability to work. Despite what appears to be a pretty clear pronouncement, confusion remains. Much of that confusion is likely based on the fact that there are biological differences between men and women, which cause courts and legislatures and employers to wonder, what does equal treatment on the basis of sex mean? Does it mean equal, equitable, identical?
And so, Julianne, I see this come up frequently in parental leave policies. Should parental leave policies be the same for men and women, for the people who give birth and the people who don't give birth? Should they be different? How does this fit into that?
Great question. I think that a leave policy that gives women more leave, parental leave, than men, but which does not distinguish between the medical recuperation period for a delivering mother is probably going to be held to be illegal because it is providing women more leave than men. However, if the policy specifically allows some of the parental leave policy to be for medical recuperation from the delivery, I think giving women more leave time for that specific purpose would likely pass muster. But I agree with you that it's an important question that many employers are struggling with, particularly as more states require parental leave policies.
Or even if there's an adoption or some sort of surrogacy where the medical condition isn't affecting the employee or the employee's partner.
Exactly,
yeah.
Exactly. So even the United States Supreme Court has struggled with this particular issue. And on the screen are just a few representative cases to show kind of that the decisions are really kind of all over the place. The Newport News case in 1983, the Supreme Court held that a health insurance plan that allowed more extensive pregnancy benefits for female employees than for female spouses of male employees discriminated against the men under the Pregnancy Discrimination Act. A few years later, the same court found that treating pregnant women more favorably than other employees is not a problem because the Pregnancy Discrimination Act is intended to be a floor and not a ceiling. The final case listed on the slide is the Young versus UPS case from just a few years ago. And in that case, the Supreme Court found that the plaintiff, who was pregnant, created a sufficient issue of fact where she offered evidence showing that the employer, UPS, had accommodated others who had lifting restrictions, but had not accommodated her lifting restrictions, which were due to her pregnancy. Although the Young versus UPS case was a pregnancy discrimination case, the court's analysis looked a lot like the ADA accommodation analysis that we're all familiar with under the Americans with Disabilities Act. So what about pregnancy and the ADA? Under the ADA, pregnancy is not a disability per se. However, pregnancy-related conditions can constitute a disability requiring accommodation under any of the three prongs of the disability definition. The ADA also requires accommodating requests for pregnancy-related conditions, and that such requests should trigger the interactive process under the ADA. In a direct response to these varying decisions and in follow-up to the Supreme Court's decision in Young, earlier this year, Congress introduced the Pregnant Workers Fairness Act. The purpose of this law is to eliminate discrimination and to promote women's health and economic security by securing reasonable accommodations for workers whose ability to perform their jobs are limited by pregnancy, childbirth, or a related medical condition. This law has passed the Senate, it has passed the House and has bipartisan support in the Senate. There are some continuing discussions about possible religious exemptions. However, the prospects for passage appear very good. In addition, it is probably not surprising to some of you that the Pregnant Workers Fairness Act is consistent with the laws in 31 states and 5 cities, which are already in effect. Just to highlight a few key provisions of this new law, which we can expect to be passed at some point in the year, the PWFA will require reasonable accommodation to known limitations related to pregnancy, childbirth, or other conditions unless the employer can show undue hardship. So very much like the court's analysis in the Young UPS case and very similar to what we're already familiar with under the ADA. The law also prohibits denial of employment opportunities if the denial is based on the need to make accommodations due to pregnancy, childbirth, and related conditions. and it will prohibit requiring a qualified candidate to take leave, paid or unpaid, if another reasonable accommodation can be provided. Finally, the law will prohibit adverse action against a qualified employee on account of the employee requesting or using a reasonable accommodation for pregnancy, childbirth, or a related medical condition. Keep in mind that this Pregnant Workers Fairness Act is consistent with the current EEOC guidance on pregnancy. In general, the EEOC says that employers should treat pregnant women the same way as other employees are treated in their ability or inability to work. Specific as to the COVID vaccine, earlier this year, in May of 2021, the EEOC issued guidance specific to the COVID vaccine. The EEOC's guidance says that employees who are not vaccinated because of pregnancy may be entitled under Title VII to modifications if the employer makes modifications or exceptions for other employees. Those are the same types of modifications like those made on the basis of disability or religion. The EEOC's guidance also cautions that supervisors should be trained to know how to handle requests for accommodation to avoid disparate treatment in violation of Title VII. Earlier in the program, I heard Sunny and the Erics talk about a development of FAQs for employers. This would be a perfect example of a development of an FAQ to assist supervisors who have to field these accommodation questions. In addition, when considering requests for accommodation based on pregnancy, you want to not forget about the CDC's guidance on vaccines. And specifically, the CDC recommends vaccination for women who are pregnant, recently pregnant, including nursing mothers, trying to get pregnant or who may become pregnant in the future. And there's scientific basis for this recommendation. Despite the clear direction from the CDC, only 31% of pregnant women are vaccinated. Also, when you're considering requests for these accommodations from women who are pregnant, you want to not forget about the state conscience laws. I won't go into that in detail because Eric Eisenman mentioned it in his presentation, but there are laws in many states, including Illinois, that are written broadly enough to cover an objection to a vaccine mandate for certain employees in the healthcare industry in particular.
So Julianne, let me ask you a quick question. Are you seeing pregnant or nursing mothers seeking exemptions from the vaccine simply based on their pregnancy?
Yes, I think many of us are seeing those kinds of exemption requests, and it puts the employer in a difficult position. One, there is real fear on the part of pregnant women that receiving a vaccine, which many view as untested, that they're just legitimately concerned about putting a foreign object in their body and the potential effect on their unborn child. The guidance suggests that if the woman who makes the request has a note from her doctor, that the medical reason for the request should be handled as any other medical disability request for exemption under the established ADA process. It's much different when it's simply based on fear, and there, the EEOC would encourage education, but it's as a practical matter, many of these women are offering medical notes from their doctor, and it may not be an undue burden to grant an exemption on a temporary basis because, of course, eventually the pregnancy condition will resolve. So just wanted to review a few takeaways. Treat women who are pregnant who are affected by childbirth or pregnancy-related condition as you would any other employee. In assessing vaccine exemption requests, consider the available guidance, and stay tuned on the Pregnant Workers Fairness Act. Anne, I'll turn it over to you.
All right, thank you, Julianne. So both Julianne and Barb have talked here today about issues related to sex and what we would consider the traditional gender, male, female distinctions that we've heard of, but we have seen it is expanding. And I'm going to discuss today the ever expanding definition of sex and gender and how that's influencing the workplace and the changes that you will need to see in the workplace. So as Ashley mentioned earlier today, in June of 2020, the Supreme Court of the United States issued a landmark decision, the Bostock case, holding that Title VII, the definition of sex, encompassed gender identity and sexual orientation. So after that decision came out, there were obviously a lot of questions and issues that came up for employers on how to deal with this expanded definition of sex under Title VII. So in accordance with that, in June of 2021, the EEOC issued non-binding guidance to help employers prevent discrimination against transgender individuals. And with that expanded definition, what the EEOC was trying to do is say employees still have to be held to the same behavior and regulations of the workplace, but you cannot treat transgender individuals differently based on the change in their sex. So the employers are still permitted to offer sex segregated bathrooms, locker rooms, showers, but employers may not, however, deny an employee equal access to facilities that correspond to their gender identity. So in other words, like you see here on the slide, all men, including transgender men, should be allowed to use the men's facilities, and all women, including transgender women, should be allowed to use the women's facilities. So not only did the EEOC address that, they also talked about the use of pronouns and how using pronouns inconsistent with an individual's gender identity could be actionable harassment in certain circumstances. So the EEOC has provided guidance on how to address the use of proper pronouns in the workplace so that you could avoid harassment suits, how to interact with employees on allowing them to use the proper pronoun, how their coworkers can use the proper pronouns, and integrating these changes into the workplace. And so that was all under federal law.
So Anne, we have pretty good guidance under federal law, but what are the states saying? Because some states have defined gender identity in state statutes.
Yeah, absolutely. So that was under federal law. It is changing under state laws too. There are quite a few states who have included in the definitions of their in their anti-discrimination statutes different gender identity, the definition of sex, to include in their anti-discrimination statutes so that those individuals are not discriminated against. I think one of the biggest examples we have here recently is the Hobby Lobby versus Somerville case that came out of the Second Appellate District in Illinois. It's really a landmark case that we believe we're going to see a lot of other states and courts citing to for transgender rights and in the workplace. In that case, Megan Somerville, she was a Hobby Lobby employee from July 1998. She's actually still a current employee, born and designated as male at birth and legally transitioned to female in 2010. What's interesting about this is that Hobby Lobby actually accommodated her transition in all ways but one. They changed her paperwork to identify her as female. They changed her benefit information. The only area that they did not accommodate her was they refused to let her use the women's restroom. So Hobby Lobby did some things that they thought could prevent some liability. They installed a unisex bathroom at the store, but they still denied her access to the women's bathroom. And as a result, Somerville began suffering from emotional distress, anxiety, embarrassment. She actually would clock out. And walk to the store next door to use the bathroom that was consistent with her gender identity. So as a result of that, she ended up filing a charge of discrimination with the Illinois Department of Human Rights. And she alleged that she was discriminated against based on her gender identity in violation of Article 2 of the Illinois Human Rights Act and Article 5. So she said that Hobby Lobby discriminated against her by treating her differently in the terms and conditions of her employment based on her sex, and that as a place of public accommodation, they also denied her equal access to the facilities. So Hobby Lobby's main argument in that case was not that it was sex discrimination, it was that it wasn't a gender identity policy, it was a sex policy, and that she was being treated differently based on her genitalia. So they said that she had to use the restroom that corresponded with the genitalia that she had at birth. Well, the Illinois Appellate Court wasn't buying it at all in this case. And they said, frankly, you just have to look at the plain language of the statute, which defined sex as the status of male or female. And the court said that status is not something that stays with you. For example, they compared it to marital status. You don't always have to stay married. So they said that sex is something that can change, and therefore, because the act did not talk about genitalia and make that distinction, and because the status of being male or female could change, this really was a sex discrimination issue. So they held that Hobby Lobby violated Somerville's civil rights by denying her, but not other women, access to the women's bathroom. And the things that Hobby Lobby argued, such as installing a unisex bathroom, didn't cure that actual discrimination by treating her differently than other women. And Hobby Lobby's argument that fear or discomfort of others was just not a justification. They could provide no evidence whatsoever that that was a valid argument. So this Hobby Lobby case really is going to be a landmark case that I think you're going to see other courts citing to as we go forward. So really that takes us to, what in light of Hobby Lobbies can we do as employers? What practical tips can we do to ensure that we are not running afoul of this and that we are assisting transitioning employees and non-binary employees in the workplace? So some of the things that we can do, addressing the issues related to a transition with confidentiality and privacy, making sure that the employees are aware that you're going to handle this in a confidential and private manner. Communicating clearly, leading by example, being proactive in having meetings with the employee who has announced that they are going to transition, developing a plan, developing a timeline, involving HR, involving management, addressing the issues that come with transitioning, and not even necessarily transitioning, addressing names and pronouns, how they would like to be addressed, when you would like that to happen, when you would like the name change to occur, and then ensuring that the other employees use the names and pronouns associated with the employee's gender identity when communicating or referencing. Increasing awareness and training employees. And this is something that can be done through policies, changing your policies to use gender neutral terminology, for example, they, them, training on that, and then ensuring and listening for that throughout the transition to make sure that the employees and the coworkers are working on using the correct pronouns.
And what about third parties, either coming into your workplace or places that your employee goes as part of their job duties?
Yeah, absolutely. So this is a very interesting issue, Barb. And I think a lot of employers will find that state statutes for anti-discrimination are being expanded significantly. And that would include covering, not only your employees, but contractors, consultants, or anyone coming in to your workplace. So that would encompass anyone coming into your workplace would be covered. And you have to ensure that they are not discriminated against. And that goes for any employees that you have that go out and work with a client. If issues arise, addressing that with the client, addressing the fact that there may possibly be laws that they need to adhere to as well, and that you want to work together to ensure that the employees are treated fairly and treated fairly according to the law. So with that being said, there's some do's and don'ts when you have employees who are transitioning in the workplace and employees who would like to use non-binary pronouns, being open-minded, discussing with the employee their needs and concerns, but not making assumptions about a person's sexuality or gender, making it clear that the conversations will be kept confidential, but not being afraid to ask questions. The other things we can do as well, asking employees how would they like to inform their coworkers, if at all, of their transition process. And if they would like to inform their coworkers, making sure that gossip or rumors are not occurring in the workplace. So really what it all comes down to is listening carefully to what the employee tells you about how they would like to be treated, and working with them to create a gender transition plan, keeping in mind with our typical ADA requirements, not sharing the employee's personal or medical information, and always not expressing personal opinions regarding the employee's professional appearance or tolerating any inappropriate or harassing conduct. And with that, I think we will take it back to AJ and Brittany to close us out for the day.
Thank you so much, Anne. And welcome back, everybody. We have come to the end of our presentation, but before we send you off, we have just one more poll question. So hopefully everybody is still awake and ready to answer, and then we'll be able to close it out.
That's right. So our last poll question asks the important topic of how interested are you in attending the next Husch Blackwell virtual labor and employment seminar? And you've got 4 options there that I think really run the gamut of emotions you may be feeling. You're either extremely, very, some of those, or all of those. So take a moment to get your answer in, and then we will take a look at the results.
Nice.
Very happy to see that extremely is the winner on this one, and the others are well represented.
Yeah, really nice. I probably would have gone with all of the above, but that's just me. Thank you, everybody, so much for joining us today. We really hope the information was helpful and useful to your organization. As a reminder, this program has been approved for HR and legal education hours. To report your hours, go ahead and just click on that CEU icon at the bottom of your screen.
You will receive a certificate of attendance, including a course number, by email at some point tomorrow, along with a link to the recording of this webcast for sharing and watching.
Yeah, and please be sure just to take a few moments to complete our short survey. We really do read every comment, and we use your feedback to plan for our future programs so that they are applicable to your business needs. And that concludes our program. So thank you.